Hey everyone, a new lawsuit out of New Jersey has two physicians suing the state of New Jersey and its medical board for constitutional claims, saying that there are telehealth regulations that require out-of-state practitioners to hold a license to see patients in New Jersey. They're calling that unconstitutional violation of their First Amendment rights and of the Commerce Clause provision of the Constitution. So let's dive into this case, what they're claiming, what they're arguing as far as the legal reasons behind, why they might be successful or not. And then I'll give you my predictions on whether it's going to be a worthy challenge, whether you should get your hopes up or not, and then what I expect to come from it and what you can do instead to make sure you can expand your practice legally and safely. So let's jump right into it. So it is a lawsuit filed in the U.S. District Court for New Jersey. It's titled Shannon McDonald, MD, et al., which means and others, versus Otto Sabando. And it's primarily two physicians and then two plaintiffs that are also patients. They are suing New Jersey, saying that their licensure restrictions on the use of telehealth are unconstitutional. As we all know, any followers of Functional Lawyer for any length of time, people that have read my book, The Practice of Telemedicine, will know that licensure of medical professionals, here MDs and DOs, is in the jurisdiction of states to decide and regulate. But the plaintiffs are saying that New Jersey's licensure laws violate the Constitution, infringing on basic rights, and should be struck down. So there's basically two families, two distinct cases, but they've joined together in this lawsuit. So they are specialists from out of state. One of the plaintiffs is a patient. It's a child, JA, that required specialized cancer treatment from Dr. McDonald, a radiation oncologist at Mass General in Boston. She has expertise in pediatric oncology and proton therapy. Her patient was a New Jersey resident, and while treatment for the condition is and has been successful, he still needs periodic check-ins with Dr. McDonald, who doesn't hold a New Jersey license. So they're claiming that because she doesn't hold a New Jersey license, it's such a burden that the patient either has to travel to Massachusetts or that she has to spend a couple $100 to get a New Jersey license. And so for those reasons that we'll get into in a minute, this law is unconstitutional. The second kind of line of facts is a patient, Hank Jennings, a college student from New Jersey who had craniocervical junction chordoma. And he got treatment from Dr. Paul Gardner, a neurosurgeon at the University of Pittsburgh. He's not licensed in New Jersey either. Follow-up visits, again, cannot occur via telehealth because he's not licensed in New Jersey. So let's jump into what New Jersey's laws say. And this is similar in every state. A healthcare provider who uses telemedicine or engages in telehealth while providing healthcare services to a patient shall, 1, be validly licensed, certified, or registered pursuant to New Jersey law to provide such services in the state of New Jersey. 2, remain subject to regulation by the appropriate state licensing board. 3, act in compliance with the existing requirements regarding liability insurance. And 4, remain subject to New Jersey jurisdiction. And the penalties for this is criminal and civil liability. Therefore, McDonald and Gardner, the two doctors, could face such penalties if they treat their patients without a license when the patient's located in New Jersey. This is what we've been saying for a long time. So here's some of their arguments and what you guys tell me in the comments what you guys think might happen or what you hope will happen with this case. So the first one is the Commerce Clause and Dormant Commerce Clause kind of line of reasoning, which, if you're not familiar, the Commerce Clause of the U.S. Constitution gives Congress the right to regulate interstate commerce, not the states. And the Dormant Commerce Clause is kind of the inverse of that, meaning if Congress doesn't pass a law specifically, under the Dormant Commerce Clause doctrine, states can't unduly burden or interfere with interstate commerce. So the patients are saying the licensure laws regulate and impact interstate commerce because practitioners in other states can't use telehealth to provide services in New Jersey without a New Jersey license. In some cases, arguments can be made by states where a violation of the Commerce Clause is not found, such as protecting the public's interest, and that's likely going to be the defendant's answer. They haven't answered yet. Their answer is due March 16, 2024. And we'll do an update video when that comes out. So in this filing, the plaintiffs are saying that state law appears to be more about protecting local physicians from competition that has the opposite effect on the public as it limits specialized care outside of the state. That would probably be the only way they'd be successful, and we'll cover that in a second. And so they're saying that the law is unduly burdensome because it's really protectionist and not protectionist for the physicians of New Jersey and not protecting the public interest of the patients in New Jersey. So they're saying it's causing patients serious harm by not having access to specialty care. This has been an argument that's happened over the years, and this one is most likely not going to be successful. Because about a year ago, these 9 justices, so the Supreme Court, but more specifically, these 9 individuals, shot down a very similar argument in the case of National Pork v. Karen Ross, who's the Secretary of California FDA, effectively. And so California passed a law known as Proposition 12, stating that you couldn't sell pork in California unless the pigs were treated well. So it was like a pork treatment case, meaning they needed larger pens. Well, most of the pork that California sells and consumes comes from out of state. So all the other pork producers in the country had to basically double the size of their pigs' pens in order to comply with this California law. They brought a lawsuit saying this interfered with interstate commerce. Millions of dollars have to be spent per pork producer in order to retrofit some of their pork pens, pig pens, and thus it's an undue burden on interstate commerce. Dormant Commerce Clause was the argument. However, the Supreme Court said, no, this was actually okay for California to regulate this as a matter of protecting the public interest because it's not unduly burdensome. It's not protectionist of California pork producers, such that California pork producers also had to comply with this law. So it was everybody in the same industry had to comply with it. And so they struck it down on those grounds. And for that reason, I don't think this one will be successful either. Any physician that wants to see patients in the state of New Jersey must hold a New Jersey license. And that's common across the whole country. So I don't believe it will be unduly burdensome. Whereas there's a similar case for the dentists in North Carolina a few years ago, where the dental board set a rule that only dentists could do teeth whitening services. But it turned out that they were only saying that because they didn't want to have competition from cosmetologists and others who were offering teeth whitening. And so they passed this regulation just to protect dentists only. And so then that one was tossed out as a case where it was too protectionist. And so not great for, it could be struck down under constitutional grounds. And so the point I'm making here is it's not unduly burdensome, or at least it would be much less burdensome when you compare it to the pork producers for a physician to get a $500 license, right? Especially when New Jersey has alternative means for out-of-state providers to get those licenses. New Jersey is a member of the Interstate Licensure Compact, IMLCC, Interstate Medical Licensure Compact, imlcc.org. And so I don't think that will likely succeed. Their second argument is the Privileges and Immunities Clause. So the Constitution notes that all citizens are entitled to the rights in that clause, one of which is the right to practice an occupation, and that an out-of-state citizen can enjoy the same privileges as an in-state citizen. So the plaintiffs are arguing that New Jersey licensure laws unduly burden the out-of-state physicians because they have to get a license when maybe only a handful of their patients come from that state. Again, not likely to win because states have historically held what's called police power, and part of that police power is protecting the health and welfare of their citizens. And so it's been well documented that medical boards and licensing laws of all professions are designed to help protect patients from people who are not really regulated to practice medicine. So they just want to make sure that you have the ability and not any discipline on your license, or more accurately, they don't want people that don't have any training at all to be practicing medicine. So there is a licensure provision there. And they say the First Amendment protection on speech. So this one's kind of a novel argument where they're saying because it's only regulating speech between a doctor and a patient, that this violates their First Amendment rights and the government has to review the speech for the content of the speech. But it's really reaching, because that would invalidate all licensure laws from all professions, right? Because the conversation had to be reviewed for the content, that it's a content restriction on free speech rights. And that one is very much a reach. And I think not likely to succeed very far at all. The first two might make it a little further. That one will be hard. The First Amendment is restricted. Like you can't yell fire in a crowded venue like a theater, because people will start running and people will get injured. And there's many restrictions on your free speech that are legal and have been followed for the last 200 years. About 200 years, 400 years. How long have we been in a country? 300 almost. So there's a lot of restrictions, and I don't think that one will work. What's kind of unique is the due process clause arguments, where this no state can deprive any person of life, liberty, or property without due process of law. So they're saying the plaintiff, and more specifically his father, the minor, are arguing that their right to seek lawful medical care for their child is being impeded by the state's licensure law, and therefore his due process rights have been violated. This is interesting. Parental rights to direct the healthcare and upbringing and education of their children are strong. However, when balanced across the state's interest in protecting all of its citizens from harm, that one might be a little bit of a closer draw, but we'll see. I don't have a crystal ball, and that is sort of a newer argument here. So that's something to keep an eye on. But ultimately, I don't think this case will go very far. I think it will get dismissed pretty quickly, and I think it will get appealed to the appeals court. And I think the people bringing it, it's being brought by a nonprofit. I think they're trying to get it to the Supreme Court. So I don't have a crystal ball. I don't know what courts are going to do. That's just my opinion right now. And I'll eagerly await what the defendants will say on March 16th. But it is something we're keeping an eye on, because this is sort of a novel idea. If the plaintiffs are successful and New Jersey's law is invalidated, that would mean that one medical license in America would go across basically every state. And that would be really cool from a telemedicine standpoint. But from our history as a country, I don't know that that would actually happen. And I think the justices at the Supreme Court would be very cautious of invalidating a state law like this, because then what's next? The domino effect is then lawyers can practice in every state, and accountants don't need state licenses. And, it kind of just is a slippery slope for all of the rest of the licensed professions across the country. So if not for the actual legal arguments, I think because of the result that would accrue, I think it would be very difficult for the justices to get their heads around it. But again, they often come up with surprising results. So we never know what they can do. If you want to read more about National Pork, or this case, it's Shannon McDonald et al. V. Otto Sabando out of New Jersey. You can read National Pork at scotusblog.com. Search National Pork. It's a great place that follows the Supreme Court, scotusblog.com. And be sure to follow Functional Lawyer for all updates on this. As the defendants make their response here towards the end of March, we'll come out with a new video and analysis on that one as well. So hope to see you soon at the next video, but let me know what you thought. Do you think it'll be successful? Do you think they should or should not win? Tell me in the comments below, and we'll see you guys in the next video.